Welcome to this week's quick lecture on judicial behavior. It is our second part in our discussion of the judiciary. So where we left off last time was the case of Marbury versus Madison and the idea of judicial review. So judicial review, as a recap, is the idea that courts, and in particular the Supreme Court, can act as a check on the other branches so that the Supreme Court can review pieces of legislation passed by Congress and actions of the executive branch or the president. When people talk about judicial review today, there are kind of two separate questions. One is the question of Marbury versus Madison. Can the court look at the case at all? Can it make any decision in the case? The second question tends to be more prominent, especially in popular culture, which is how judges review the activities of other branches and sometimes of the states. We still call that judicial review, but the idea of it is of interpretation and constitutional interpretation. And so constitutional interpretation is kind of a continuum. And it's easy to say there are originalists and there are living constitutional people and there's no one in between. But that's just not the case. There are stricter originalists and there are looser ones. There are people who kind of fall in the middle and are more moderate. Those tend to be your swing justices. But it's not a perfect continuum, but it is a continuum. So I wanted to talk about that a little bit because it's part of our popular understanding of the Supreme Court, but also our understanding of courts in general. Originalists generally believe that the role of the courts in interpreting the Constitution is to read the Constitution as it was written and not interpret anything new into it that was not there when it was drafted. So, for example, the right to bear arms would be something interpreted around the time that the amendment was put in. There are those, though, who believe that a document that is living is more, it will stand the test of time more. Now, this takes a variety of forms. Sometimes that does look like a reviewed look at how we interpret different portions of the Constitution, and sometimes it just means interpreting the Constitution in light of new developments, new technology, new borders, etc. I have, in addition to this lecture, put up two videos that I typically show in my American government class. One is the late Justice Scalia talking about originalism, and the other is Justice Sotomayor talking about a more living Constitution doctrine, although she eschews that particular term. When political scientists look at the decisions that courts make and judges make, there are two kind of distinct models. The first is the legal or structural model, and this is the oldest model, and it's the model that people with a legal background tend to believe in more. And the legal model says that judges decide cases somewhat uniformly on facts and law. They don't let personal ideology play a role. And this isn't to say that legal actors are all robots and have no thoughts of their own, but that through legal training and the socialization in the legal world, people kind of put aside some of their own ideologies. And there is something to be said about that. For those of you who go on to law school, you'll note that you think and write differently after law school. The way in which you see the world changes some. But that is a very oversimplified view of how people make decisions. And so the attitudinal model has been developed. And the attitudinal model says that judges have ideologies, that yes, they have their legal training, and they're part of the legal kind of constellation of actors, but they have ideologies that are shaped by the times in which they are raised and come of age, the political actors around them, and sometimes public opinion itself. The attitudinal model says that there's a myth of legality, that there's this idea that there's one down the center legal way of doing things, and that everybody else that doesn't follow that kind of falls outside of that. And that's just not true. There are reasonable interpretations of legal documents that can counter one another. So the attitudinal model says that judges have ideologies and might be using those, and in fact do use those in a variety of ways. So to measure ideology, political scientists have come up with a variety of ways. The first and the most long-standing, and the one that we tend to hear about the most in the news, is to look at the party of the appointing president. The president that appoints the judge or justice, the party dictates how that judge or justice will act. So when we hear about, for example, the judges that decide the cases on the Trump travel ban, the first thing we hear about is who appointed those judges. Likewise, when we hear that an important case is at the Supreme Court, we tend to think about the party of the appointing presidents in relation to especially the swing justices, but the justices that are on the bench. There have been two other types of scoring that have come out. Common space scores are a little more complex for judges at the circuit level and the district level, and they look at not only party of appointing president, but things like state political culture and so on. And then Martin Quinn scores look at how justices decide cases over the years. And so that's actually what you're seeing on the right there is a diagram of the Martin Quinn scores, which track the ideology of Supreme Court justices over time. And you can see that people don't tend to cross over as much, that usually people don't become that much different than they were when they were appointed, except to the extent that there is this idea that justices might become a little more liberal, although that only tends to ring true of certain justices. So we need to draw from this a couple of things. One is that we still look to the political party of the appointing president as one way to measure what a judge might or might not do, but that political scientists have come up with additional ways of determining judicial behavior, whether it's predictive or not, or whether it's just a way to interpret judicial behavior. That depends on who you talk to. So that brings us to our two readings this week. I want to talk about the Mishler and Sheehan reading first. The Mishler and Sheehan reading talks about measuring the influence of public opinion on decision-making in terms of Supreme Court justices. That says judges, it should say justices. It looks from the period of 1953 to 1992. And it says, as its hypothesis, that they believe that public opinion does affect the way in which Supreme Court justices decide cases. What they find is that that is true of some justices, but not others. And the ones that it is most true of are the ones that are somewhat near the middle. So if we were to look back on this, the ones that track that black line, which is the median, the ones that are closest to that are more likely to be swayed by public opinion than the ones on either side. And so we hear a lot about this, like who's the swing vote, and right now it's Justice Kennedy, those are the ones that are more susceptible to public opinion as an influence in how they decide cases. So what Mishler and Sheehan, what their writing stands for, is the idea that public opinion can influence justices. So this is definitely the attitudinal model and not the legal model. But that who it influences is probably more limited than people might otherwise anticipate. Then there's the Gibson and Caldiera reading. The general thrust of this is this question: do people think less of the court if they understand that justices are human and may use their own personal ideologies? In other words, there are people who think the reason why the Supreme Court is the most trusted institution, and it is the most trusted institution in the federal government. The reason why that is, some people argue, is because we see the court and the justices as impartial actors in a way that we don't see Congress or the president. And so what they did is they tested people's views of the justices to see if they were, in fact, neutral in terms of whether they thought they were ideologues or whatnot, and then whether they thought the branch, and in particular the Supreme Court, was still legitimate, that it was still a legitimate form of government and had legitimacy. And so they talk about what they mean in terms of legitimacy. And what they find is that people actually don't think less of the court, and meaning they don't think that the court is illegitimate just because they understand that justices use their ideologies. They expect justices to have differing opinions, and they don't think less of the court because of it. Now, what you see here is a picture. On the left is Justice Ginsburg. On the right is the late Justice Scalia. They ideologically are completely opposed to one another, or were completely opposed to one another. And yet they were great friends. There was an opera written about them. They sang in an opera together, or they had a speaking part, I believe. But they were great friends, opera buddies. And we tend to read more into that in some ways than we do into the ideologies. We don't think the Supreme Court is less valid of an institution because the justices have ideologies. Now, whether we think differently because they're not elected, that might be more the case. But Gibson and Caldiera say it isn't that people might think, oh no, personal ideologies play a role, so we delegitimize the enterprise. They, in fact, argue the opposite, and their results show the opposite. So that brings us to the end of this discussion. I told you it was quick. Here's what I want you to pull away from it. One, the idea of originalism versus living constitution. Two, the difference between the attitudinal model and the legal model, and what components may ring true in both. And then kind of the main draws of these readings, that people understand that the court is ideologically driven, that justices are ideologically driven, but it does not delegitimize them, and that public opinion plays a role on how the moderate justices, at least, act. All right. Talk to you next week.